Is this just delaying what might be inevitable, which is these charges being dropped, or could this ultimately make his prosecution go forward?
I think it's unlikely that this would make the prosecution go forward if the Department of Justice is not going to change its mind about whether it wants to pursue these cases. But that said, the court has the authority to review the reasons for the dismissal. And I thought that the judge's order today very sensibly appointed amicus curiae, friend of the court, to help him sort through the relevant issues here. He appointed a very well-respected conservative lawyer, Paul Clement, to help him brief issues on which he otherwise would not have the benefit of the adversarial process. Usually, when a judge is deciding a motion, the judge hears argument from two opposing sides. But that's not what's happening here. You have the Department of Justice and Eric Adams aligned in arguing that the judge should essentially summarily grant the motion to dismiss. But the court has an obligation to determine whether the dismissal is in the public interest and whether the reasons are legitimate ones that he should lend the court's imprimatur to. And so I think it's a very sensible move for him to appoint outside counsel to assist him with briefing on these issues.
Well, let's keep going down this road, Professor. The judge asking for submissions by March 7, and we'll hold a hearing about a week later, if necessary. What will happen in that hearing, assuming it takes place?
So as I read the court's order, what's going to happen at that hearing or oral argument on March 14th would be argument essentially on whether there should be further proceedings. Because what he's asked Mr. Clement to brief, among other things, is what evidence or information the court is authorized to take into account in deciding whether to grant the motion to dismiss, and also what would be the practical implications if the court were to deny the motion, in effect acknowledging that even if he denies the motion and the Department of Justice doesn't change its mind, that at the end of the day, the prosecution would have to be dismissed for lack of pursuing it on the part of the Department of Justice. So depending on how the briefs come in, and if there's argument on March 14th, it's possible the court could actually schedule subsequent proceedings before him where he could take evidence and further argument.
Well, when we consider what that evidence would look like and what the concerns were originally that have kind of resulted in this further inquiry, how hard is it, Jessica, to prove a quid pro quo?
Well, I think what's important here is that it's not necessary for the court to find a quid pro quo per se. If the court finds that having the charges dismissed in order to allow Mayor Adams to pursue the president's immigration agenda, which is plainly what is on the face of Mr. Bovey's motion, that is not in the public interest, and that is not something that prosecutors should be factoring into their decision about whether to pursue a case that's already been indicted by a grand jury, then the court could find, again, without determining there was precisely a quid pro quo, that it would be improper to actually grant the motion to dismiss.
A lot of people were really confused about Kathy Hochul's decision yesterday to not try to pursue an ouster here of the mayor. Without turning you into a political analyst here, we'll stick with the legal side. Does this give you a sense that had she activated this inability counsel and gone through the motions of kicking him out of office, that it would have ended up being contested in court?
Well, I think that's what's important for people to bear in mind, is that even if she had decided to exercise her authority to oust the mayor, that would not necessarily have been a quick process that would have been over without further court proceedings as well. The mayor would, I think, contest that not only the decision, but also the process. I mean, he'd be entitled to a hearing, and it's not clear exactly what that hearing would require, what he'd be entitled to under the law. So people may be disappointed politically in her decision, but I think that people should be clear-eyed that that was not likely to be a very quickly resolved matter either.
Well, it wasn't just what we heard from the governor regarding Eric Adams specifically and not removing him from office, but other guardrails that she's putting into place, including, she said, providing more resources to certain areas of the New York City government, like the comptroller, in order to pursue legal action against the federal government. And I wonder, Jessica, what that signals to you about how litigious things could get between state governments and the Trump administration.
I think we're already seeing a lot of litigation between states and the federal government. So perhaps this would just sort of add to that, add resources to it. It's hard to say whether, if her proposals were enacted, to what extent that would actually marginally change the amount of litigation that we're seeing.